Joining us at this moment is the Defence Counsel for Jignesh Mewani, Advocate Anshuman Bora. Today he has been produced in the court of the Chief Judicial Magistrate Borpeta in connection to the second case. What have been the proceedings in the court? You have moved your bail petition.
Yes.
What can you share with us?
We have made today he has been produced in the morning itself before we arrive. The reason is very simple. Before my arrival they wanted to take the custody, but we have requested the court to hear our bail application. Accordingly, we filed the bail application today morning itself, and the court was pleased enough to take up our bail application, and accordingly we moved the bail application. And the main contention of in the bail application is that there is an absolute violation of fundamental rights of my client Jignesh, because of the fact he has been not intimated in the Kokrajhar court. There is one more case is pending against him in nearest district. This is the mandate of the Supreme Court, that if there is more than one case is pending against one accused who is in detention, it is mandatory for the prosecution to intimate him that one more case is pending, so that he can take the legal course for the other case. But in this case, he has not been intimated even in the nearest court. Not even neither the court has been intimated who has granted bail. There is a judgment of the Supreme Court in Farooq Abdullah's case in 1983 itself. It is the mandate of the prosecution to intimate that there is one more case is pending against him to the court who is granting the bail. They have not done it. They have not disclosed. There are two forwarding reports in this Kokrajhar case, but they are silent about the fact in that two forwarding report that the Jignesh has committed this offence also. In that two forwarding report, why, if he has committed the offence in the journey, they could have given that indication in the forwarding report that while in the journey he has committed another offence. The two forwarding in two different dates, his absolutely prosecution is silent. The investigation is silent that he has committed one more offence in Borpeta, outraging the modesty. They were silent till yesterday. Suddenly, yesterday after the granting of the bail, they have come up with this case. There is a violation of the recent Supreme Court judgment of the Arnesh Kumar that the accused is entitled if the offence is less than 7 years. In this case, all the offences less than 7 years, punishment is prescribed. So 41 notice is also necessary. He was in the custody. They could have served the notice that you are also required. Why they have concealed this fact? Because of the fact so that I cannot move any bail application in High Court and the Supreme Court to get the anticipatory bail in other cases. So intentionally investigating officer, violating the mandate of the Supreme Court, has considered all the facts. So the Supreme Court says if you violate all these conditions, then the detention is absolutely illegal. So we are hoping that this court will definitely see to that, the violation, and definitely the court will pass the necessary order with his wisdom.
Also, yesterday, lawyers from your team defending Jignesh, they told us that they were facing some hurdles even to get a wakalatnama signed.
Yes.
Yes. Are you facing hurdles to defend your
Yes, absolutely,
client?
absolutely. Even my client has deprived of talking to me. He was put in the custody. Even yesterday, when he was in the police custody, he was not even allowed to sign the power, the wakalatnama, on his behalf to me. The police says he is in the custody of the judicial, and he has taken the custody without producing before the court. How can the SP say that he is in the custody of the judicial custody? He has been deprived of the signing the wakalatnama. This is what is going on. What else is required to say? And now we can't even appear without the wakalatnama. The court has allowed to sign him in his front, then we have been allowed to appear. But without the authority of the government, the public prosecutor comes from the Guwahati and he wanted to appear before the court. Without a written permission. He wanted to submission. I have objected vehemently. No, I am not give audience to this man unless and until he produces the authority from the concern that he has been appointed as special public prosecutor.
Also, the charges that have been brought in this second case against him, it seems that the incident has taken place on way from Guwahati to Kokrajhar, and he was in police custody.
Yes.
So how do you see this?
That's what I'm saying. The allegation is that he has committed an offence, outraged the modesty, when he is the custody of the police itself. On the going to Kokrajhar, on way through the Borpeta, Why they have immediately, and it was the time was 1:30 p.m. Why they have not registered immediately case here? Why they have waited for the next day? Why they have not intimated that he has committed offence in the Kokrajhar forwarding, that on the way he has committed one more offence, and this is very intimidating offence? They were silent. That means what? This is a fabricated, concocted afterthought FIR.
One last thing. What would be your? What are you planning now? Are you planning for anticipatory bail? I'm asking this because even in Kokrajhar, you were very apprehensive that even if he gets bail, he'll be slapped with more cases.
So we don't know tomorrow, because tomorrow, as far as my information, till that, apart from this, there's no case is pending. He is already in this custody of this case. There's no question of anticipatory bail in this case. But if tomorrow, if the requires, if we got to know there is one more case, definitely we'll see if the anticipatory bail is required. Definitely we'll approach the Honorable High Court.
Thanks.
Thank you.